I'm Gail Harriet, Chair of the Civil Rights Practice Group. If you are interested in joining the Civil Rights Practice Group, you can do that through the Federalist Society website. If you are interested in a leadership position within the Civil Rights Practice Group, then you can see me or Dean Reuter. My second announcement is that for those of you who are fast enough to go for it, there are free copies of Rick Sander and Stuart Taylor's book, Mismatch: How Affirmative Action Hurts Students It's Intended to Help, and Why Universities Won't Admit It. They are on the table over there. If you are interested, you can pick up a copy. With that, I am going to turn the program over to, we are just absolutely delighted to have Judge Diane Sykes here of the United States Court of Appeals for the Seventh Circuit. She's a woman who needs no introduction, so I'm going to turn it right over to her.
Thank you, and it's a pleasure to be with you here this afternoon. Our topic for this panel discussion today is sexual assault on college campuses. It's a very serious issue that has drawn increased attention from advocacy groups both on and off campus, and a corresponding response from regulators in the Department of Education and university administrators alike. Our panel today will discuss the nature and extent of sexual assault on campus and the administrative and regulatory responses to it, including the federal government's role in addressing the issue. The panel will also discuss how best to address the need to protect against acts of sexual violence on campus, while also protecting the due process rights of students who are accused of sexual assault. As always, the Federalist Society has assembled a very distinguished panel of experts on the subject who are with us here today to discuss and debate the issue. First up this afternoon will be Laura Kaufman on my far right. She is the Senior Counsel and Director of Education Policy for at-risk students at the National Women's Law Center. In that role, she engages in litigation, advocacy, and public education to advance women and girls in school and in the workplace. Before joining the center, she was in government service as an attorney in the Federal Trade Commission's Bureau of Consumer Protection, and also she worked as an assistant U.S. attorney in Chicago. She is a graduate of the University of Michigan and the law school at Northwestern University. Next up will be Heather McDonald. She is the Thomas W. Smith Fellow at the Manhattan Institute and a contributing editor of City Journal. She studies and writes on a wide range of topics, including homeland security, immigration, policing and racial profiling, and education policy, just to name a few. Her essays are collected in 2 anthologies, and her most recent book is a critique of immigration policy. She has testified before Congress on a wide variety of public policy issues, and her work has appeared in the pages of our most important newspapers and opinion journals. She is also a frequent guest expert on television and radio programs. And in 2005, she received the prestigious Bradley Prize for Outstanding Intellectual Achievement. Ms. McDonald has degrees from Yale, Cambridge, and Stanford University Law School. Next up will be Seth Galanter. He is the Principal Deputy Assistant Secretary for Civil Rights in the Department of Education. He joined the department in 2011, moving from the private practice of law here in Washington, D.C. in the appellate practice group at Morrison and Forrester. Before that, he served for 8 years as a lawyer in the Civil Rights Division at the Department of Justice. Mr. Galanter has argued 2 cases in the Supreme Court and more than 40 cases in the federal appellate courts. And finally, Greg Lukianoff is an attorney and president of the Foundation for Individual Rights in Education, also known as FIRE. He is the author of 2 books on freedom of speech, and his work has been published in leading national newspapers and opinion journals. He too has testified before Congress and is a frequent guest on television and radio programs, especially on free speech issues. Before joining FIRE, Mr. Lukianoff practiced law in Northern California and is a graduate of American University and Stanford Law School. With that, we'll begin with Ms. Kaufman.
Do you want me to come up to the podium? Good afternoon, everyone. Thanks to the Federalist Society for inviting me to participate. It's great to be here. I'm going first to frame the issue for all of you. There may be no definitive answer about the prevalence of sexual assault. There is some dispute about some of the statistics, but there can be no question that there is too much and that our students should not be subject to hostile environments at their schools. And at the college level, the best available research suggests that nearly 20% of college women are victims of attempted or completed sexual assault. That's 1 in 5 women. And it typically happens in their freshman or sophomore year. In 75 to 80% of cases, the victim knows her attacker. Many are survivors of incapacitated assault. And men are victimized too. Roughly 6% of college men are victims of attempted or completed sexual assault. According to data collected under the Clery Act is the federal law that requires higher education institutions to report campus crime statistics. According to Clery Act data, in 2012 alone, there were 4,800 sex offenses reported on college campuses. And this does not reflect the scope of the problem because these crimes are so underreported. Less than 5% of rape victims in college report their attack to law enforcement, and less than 12% of rape victims overall report their attacks. Too often, survivors are afraid to report sexual assaults, not only to their schools, but to community law enforcement or campus law enforcement or prosecutors' offices, because they fear biased treatment that denies them access to fair and impartial resolutions. This kind of treatment can traumatize them and re-victimize them. And historically, this sort of treatment has been the trend. That trend needs to be reversed. Common things we see in these types of proceedings are victim blaming and underreacting by schools. Those are some of the responses that we're seeing from schools. For example, at James Madison University, even where there was a video of sexual assault committed by 3 students, those students received no disciplinary action until after they had graduated, which amounted to to practically no action at all. The University of Southern California refused to refer a sexual assault complaint to the LAPD because the attacker didn't orgasm. The survivor was told that because he stopped, it was not rape. Even though his penis penetrated your vagina, he stopped, so it was not a crime. An Amherst student reported her assault to a counselor and was told to take a semester off and forgive and forget instead of filing a report. And Occidental College discouraged students from reporting assaults and even intimidated faculty members who criticized the school for its response to sexual violence. These are just a few examples of what's going on around the country: public schools, private schools, large schools, small schools. And there's no denying that the emotional and physical effects of these crimes is devastating to students. Victims of sexual assault often find it difficult to study, reduce their participation in school or school activities, or avoid school altogether. And some students even take their own lives. The problem, unfortunately, is not limited to the college level. At the K-12 level, according to the Federal Centers for Disease Control and Prevention, more than 10% of high school female students and 4% of high school male students reported being physically forced to have sexual intercourse when they did not want to. And the rate was significantly higher for students who were lesbian, gay, bisexual, or transgender. Sexual assault is also reported by children in elementary and middle schools, and we're currently representing at the National Women's Law Center a middle school student who was assaulted in the bathroom at her school. In 2009-2010, which is the most recent year for which data are available, public schools reported 600 incidents of rape or attempted rape and 3,600 incidents of sexual battery. Now, sexual harassment and assault are on a continuum. Unchecked harassment can often lead to sexual assault or escalate and become sexual assault, and unaddressed sexual violence often results in the victim being harassed by her peers when it becomes known that she reported this, but the school did not take her seriously. And under Title IX, sexual harassment is prohibited, and that includes sexual violence, which is really just an extreme form of sexual harassment. But either way, we're talking about a hostile environment for the victimized student. It's an environment where the student doesn't have the opportunities her peers have, such as the freedom to attend a campus party or go to the library alone, to participate in extracurricular activities or athletics, to live in her dorm without fear of confronting her attacker in the hallway, or to go to class without being re-traumatized by sitting a few seats away from her perpetrator, or the freedom to walk on campus without being harassed by a perpetrator's friend. It can damage the student's emotional and physical well-being in ways that deprive her of the opportunity to get an education altogether. And in some cases, students whose schools do not respond promptly or appropriately to their reports of sexual assault withdraw from school temporarily or even permanently. And sometimes their schools even encourage them to leave. Under the law, when sexual harassment, including violence, is serious enough that it limits or denies a student's ability to participate in or benefit from a school's educational program, and the school knows or reasonably should know about it, the school has to take prompt and effective steps reasonably calculated to end the sexual harassment or assault, eliminate the hostile environment, prevent its recurrence, and remedy its effects. Each school has an obligation to create a non-discriminatory learning environment and to ensure that students are protected from discriminatory harassment and violence. The Department of Education has been very active in enforcing the law in this area, and I commend them for that. I'll defer to Deputy Assistant Secretary Galanter to give you more details about the steps the department has taken. Yet still, we know that schools are not complying with the law. Interestingly, in July, Senator McCaskill released a report, the results of a survey she had conducted of 440 four-year institutions of higher education across the country. She did both a national sample and separate samples of the nation's largest public and private institutions. Only 16% of the institutions in the sample conduct campus climate surveys to find out how students perceive the environment, whether they feel safe, whether they know to whom they should report an attack if one happens. Only half of the schools in this sample have a hotline for survivors of sexual assault to report their assaults, and less than half give an option to report online. About 8% of those in the sample do not allow confidential reporting at all. Over 20% of schools in the sample provide no sexual assault response training for their faculty and staff members. And over 30% do not provide any sexual assault training for their students. Over 40% of the schools in the sample have not conducted a single sexual assault investigation in the past 5 years. And some institutions have reported to the Department of Education as many as 7 times more incidents of sexual violence than they had investigated. I think it's useful to also highlight for you what the military academies are doing, not because they're a perfect model, but because they are one model. They have been active in this area. The Department of Defense produces an annual report assessing each service academy's sexual assault policies, trainings, and procedures. And every 2 years, the academies conduct an anonymous voluntary survey of all cadets and midshipmen, covering a range of issues related to sexual harassment and assault. For example, respondents are surveyed on whether they've experienced unwanted sexual contact and/or harassment, their level of understanding of academy procedures for reporting sexual assault, whether they participated in prevention programs and how effective they think they were, whether they reported an incident and why or why not, and their reporting experiences, among other things. In response to the survey for the year 2011-2012, Approximately 525 students at the military service academies reported experiencing some form of sexual assault that year. But the number of sexual assault reports that went through the official process totaled only 80. Having this kind of information helps the academies focus on improving the quality of their prevention programming and addressing other areas in which improvements are needed in their systems. Schools that conduct evaluations of their prevention and response programming can help ensure that their programs meet the needs of their students, as well as send the message to students that these programs are taken seriously by the school. This in turn can strengthen the anti-violence climate at the school and help make it possible for more survivors to feel comfortable coming forward to report their experiences and to seek the services they need to continue their education. Thank you.
Thank you so much. This is a great honor. I've addressed Federalist student chapters, but this is the first time I've got to speak to the adults, so we'll see how it goes. Every year, the stampede of girls trying to get into the nation's selective colleges grows more intense and begins earlier in a girl's life. Highly educated baby boomer mothers in Manhattan pay $200 an hour to prep their female tots for the nursery school admissions exam, all in the hope of winning a slot for their little darlings at Harvard 13 years later. Girls now constitute a large majority of students on college campuses. And yet, if we are to believe college feminists and their counterparts in the Obama administration, these college-educated, sophisticated mothers are deliberately sending off their daughters to a crime scene of unprecedented proportions. According to Vice President Joseph Biden, echoing feminist bromides, 1 in 5 female undergraduates will be the victim of rape or sexual assault during their college years. Let's put this claim in perspective. In 2012, the violent crime rate in Detroit for all 4 violent felonies included in the FBI's crime index, murder, rape, robbery, and aggravated assault, was 2%. Detroit's rape rate was 0.05%. A 20% crime rate for any crime is unheard of, even in Africa's most brutal civil wars. And yet, despite an alleged campus sexual assault rate that is 400 times higher than Detroit's, female applicants are beating down the doors of selective colleges in record numbers. The consequences of this alleged tsunami of violence on American college campuses are dire, as Ms. Kaufman suggested. According to the White House Council on Women and Girls, quote, survivors of the alleged campus sexual assault epidemic often experience a lifetime of depression, chronic pain, diabetes, anxiety, eating disorders, and post-traumatic stress disorder. If there is evidence of such shell-shocked victims, it is being kept well hidden. Females graduate at 23% higher rates than their male counterparts, with more ambition, and go on to lead lucrative careers. Imagine that 1 in 5 college girls would merely have their cell phones stolen at knife point at some point during their college time. There would have been a wave of protective strategies that would have emerged. A 20% sexual assault rate should have sparked a mass movement to create alternative learning spaces for girls, such as single-sex schools. None of this has occurred because the campus rape epidemic doesn't exist. In the 1986 Ms. survey that sparked the campus rape industry and that generated the 1 in 5 statistic, 73% of respondents whom the study characterized as rape victims said they hadn't been raped when asked the question directly. 42% of these supposed victims went on to have sex again with their alleged assailant, an inconceivable behavior in the case of actual rape. 65% of females whom a Department of Justice study from 2000 deemed completed rape victims said that they did not think that their experience was serious enough to report, nor did their alleged victimization result in physical or emotional injuries. 72% of alleged victims in a recent MIT survey said that their experience was not serious enough to report. These reactions are also inconceivable in the case of actual rape, the second most devastating crime after murder. So what is going on college campuses? Not a rape epidemic, but a culture of drunken hookups with zero normative checks on promiscuous behavior in which girls drink themselves blotto precisely in order to lower their sexual inhibitions. A recent rape case at Occidental College, President Obama's semi-alma mater, illustrates what we are dealing with here. Oops, somebody's cell phone. Around midnight on Saturday, the complainant, Jane Doe, a college freshman, began her weekend drinking binge on Friday, September 6, 2013, and continued drinking into Saturday night. Around midnight on Saturday, she went to a party in the room of John Doe, another freshman whom she had just met. Jane removed her shirt while dancing with John and engaged in heavy petting on his bed, lying on top of him and grinding her hips. Jane's friends tried to get her back to her own dorm room, but before she left, she gave John her cell phone number so that they could coordinate their planned sexual tryst. Jane and John exchanged texts in which Jane asked John if he had a condom. He did. Before Jane left her own dorm room to return to John's, she texted a friend from back home, "I'm going to have sex now." Jane walked down to John's room at approximately 1 a.m., knocked on his door, went in, took off her earrings, got undressed, performed oral sex, and had sexual intercourse with him. Shortly before 2 a.m., Jane got dressed and returned to her room and began texting her friends messages with smiley face symbols. The next day, she texted John asking if she had left her earrings and belt in his room and asked to come by to pick them up. Like many alleged campus rape victims, it never occurred to Jane to think she'd been raped until she spoke with the Title IX investigators on campus. Now, I would submit that someone who texts a male asking if he has a condom, who conspires to have sex with him, who announces to a friend that she intends to have sex, who voluntarily goes to his room in order to have sex, who has sex through no act of coercion or force on the male's part, is as voluntary and responsible an agent in that sex act as the male. And yet Occidental College, under pressure from the Obama administration to get its rape conviction numbers up, found John guilty of sexual assault and expelled him on the ground that though Jane's actions and statements seemed to indicate that she consented to sexual intercourse, John should have known that she was too incapacitated to consent. What do we have here but a return to a Victorian ethos in which the male is presumed the guardian of female safety? Jane and John were both very drunk. They both agreed to have sex. Why does the responsibility fall solely on the drunken John's shoulders to evaluate the mental capacities of his drunken partner and not vice versa? Why isn't Jane equally guilty of having sex with a partner who is too drunk to consent? The alleged campus rape epidemic could be stopped overnight if women's advocates sent a simple message to girls: don't get drunk and get into bed with a guy whom you barely know. Keep your clothes on and go home at night to your own bed. Let me propose a thought experiment. An unapprehended rapist has assaulted 2 students in the parking lot of a university's medical school at night, a crime rate representing 0.04% of the campus's female population. What would be the university's response? Would it plaster the area with posters warning females not to go to the parking lot alone at night until the rapist is caught? Or would its administrators remain silent about whether girls should continue to frequent that area of the campus because, quote, rape is never a woman's fault? The first option, of course. The university would warn females against frequenting the parking lot because student safety is the administrator's paramount concern, regardless of whether female students have a right to go to that dangerous area at night. But when I suggest to campus sexual assault administrators that they could stop the alleged rape pandemic immediately if they persuaded girls to exercise more prudence, I inevitably receive responses like the following, quote, "I'm uncomfortable with the idea of recommending that females exercise more responsibility because rape is never a woman's fault," end quote. Now, there are two possible reasons why campus administrators refuse to take the most efficacious means to end what they insist on calling campus rape. That is, by counseling temperance and prudence. Either administrators know in their heart of hearts that what is happening on campuses is not really rape, but something much more complex and compromised than criminal sexual assault, almost invariably involving mixed signals, ambiguity, and voluntary behavior on the female's parts. Or, and this possibility is too horrible to contemplate, these self-professed women's advocates really do believe that a drunken hookup is rape, and yet they are withholding from women the simplest, surest way to prevent being, quote, raped, simply in order to preserve the principle of male fault. The campus sex revolution has ended up in an utterly bizarre spot. It began with students' demand to be free of any intrusive parietal oversight from college officials. Now, in a remarkable turnaround, the children of that revolution want colleges to actually write highly legalistic rules for sex that resemble nothing so much as a multi-lawyered draft contract for the sale and delivery of widgets, complete with the conditions for default. They demand the creation of Byzantine bureaucracies dedicated solely to overseeing sex, whose voyeuristic members will parse every kiss and every grope. I have news for girls and their supposed advocates. This is sex that we're talking about, the very realm of the irrational and the uncontrolled. See Ovid's Metamorphoses, Boccaccio's Decameron, and Euripides' The Bacchae, if those texts are still available at your school. Maybe St. John's, it's one of the last holdout. Norms of chivalry, courtship, and modesty once tried to channel this primal drive. With those conventions now demolished as sexist, females and males are on their own, and often at sea. A formalistic definition of consent, the current desideratum of campus sex bureaucrats, is hardly a sufficient substitute for traditional social checks on the sexual instinct, and will never be able to regulate the irrepressible and often conflicting emotions around intercourse. Much has been written about the egregious due process failings of campus sex tribunals. Mr. Lukianov will give us the gory details. Conservatives and a growing number of liberals are calling for more due process protections on campus. This is a second best solution, in my view, one that merely expands the feminist bureaucracy and the bizarre codependency between exhibitionist students and voyeuristic administrators. The solution to the alleged campus rape epidemic, in my view, is not more sex bureaucracy and legal process, but more personal responsibility and prudence. And while the legal risks regarding regretted sex are flagrantly stacked against male students, it's hard to shed a tear for them. They may not be guilty of rape, but they are almost certainly guilty of taking full advantage of the sexual caravanserai on campus and of acting as boorishly as females will allow them to. Males are the main beneficiaries of no commitment sex, for males and females are not equals on the sexual battlefield. While there may be few actual rape victims on college campuses, there are undoubtedly thousands of girls feeling confused, betrayed, and exploited by partners who leave their bed with no emotional pang whatsoever. If male students respond to the one-sided distribution of risk and responsibility by becoming sexual prudes, society will have suffered no loss whatsoever. But don't count on the male libido to do anything so sane. Thank you.
Good afternoon, everyone. You know, I think when we had our pre-meeting, I should have bargained to come before you because mine is going to seem dry by comparison. As was mentioned before, and then Greg, I don't know what you, I think we both got the...
Comparatively.
Yeah. But I'm Seth Galanter from the U.S. Department of Education, or as I might be known, a counterpart of a feminist cabal of some kind. But I'm here today to talk about a couple of things that we, the United States, are doing, and then talk about particularly harassment and sexual violence. But let me start by just repeating something that Laura said, which is the Centers for Disease Control does a representative survey of high school students. And they asked high school students, have you been physically forced to have sexual intercourse when you did not want to? 10% of high school women said yes, and 4% of high school men. That's in high school. A recent study by Professor Regnerus, which has not yet been published, asked the same question of women who were no older than 25 and had at least a 4-year degree. 18% of women reported that they had been physically forced to have sexual activity against their will. Now, those are numbers that people are reporting. I can't tell you what happened in those rooms. I can tell you that when people are asked questions about physical force to anonymous surveyors, this is what they're telling them. That is, in essence, the nature of the problem that we in the federal government are looking at. And there's lots of different studies, and I'm sure there's a million anecdotes that can prove our point, but if I told you a million anecdotes, you would say that's just an anecdote. So I started with the data. Let me start, my first point is, why is this an issue for the Civil Rights Office? And for that, you have to understand our history, which is we started as an office to desegregate the South, to prevent racial discrimination, to get kids, particularly black kids, but black and Hispanic kids, into integrated schools. And the first step, obviously, was Governor Wallace standing on the steps, blocking the way, but that was very first generation. But then you get in the school, and everyone shuns you and get pushed around in the hallway, and they write nasty things on your locker, and they make your life as miserable as possible, the so-called hostile environment. And those cases started in the 70s as race cases because kids were going to the schools, they were in the hallways, they were in the seats, but they weren't learning because everything around them was so hostile that it limited their ability to learn. And so my office, the Office for Civil Rights, the federal courts, Achieving Desegregation, worked to create this standard to prevent things that were tantamount to exclusion, the so-called hostile environment that limits your ability to benefit from the very thing you're supposed to be benefiting from. And we've been doing that, for 40 or so years. And then once we got Title IX enacted, the nation got Title IX enacted, and we, the Office for Civil Rights, started enforcing it, we saw the same issues arising when women went to traditionally all-male institutions, and when men went to traditionally all-female institutions. There was strong possibilities of these hostile environments that stop you from being able to benefit. And even today we see it, and again, anecdote, a woman wanted to be a car mechanic, went to vocational school, all-male class. She had to drop out because they made her life intolerable. Not because of sexual violence, but because of their words and their actions towards her. So even today, there's a role for this hostile environment question. That is, it's not enough just to get onto campus. Are you allowed to learn equally with your male peers? And so we in the Office for Civil Rights have this standard. It's been since 1991 when the Supreme Court first said that sexual harassment of students can violate our Civil Rights Statute, Title IX, and that we have been issuing guidance, sometimes with notice and comment, sometimes more clarifications that help institutions understand what we expect of them. But the reality is, if they get a complaint, if a woman or a man comes to them and says, I've been sexually assaulted, we're already kind of too late, right? At that point, we're dealing with how are we going to fix this going forward? So we have a whole nother strand of administration activities, which again started under Vice President Biden with the Violence Against Women Act, to try and create prevention programs to make sure that everyone, men and women, understood what was expected of them so that there wasn't rape, there wasn't sexual violence. And I'm not sure what the term real rape is doing in the conversation. The fact is, I think we have a shared understanding that there's not real battery and just battery. If you don't want someone to hit you and they hit you, you've really been battered. And if you don't want to have sex with someone and you're being forced to have sex with them, that's real rape. It is a matter of consent. But the question is, consent for what and when? And I think the point of a lot of the sexual violence work has been to educate men and women about what it means in our society to consent to sex. And what does it mean in a society that still does, as I think was discussed, have a lot of unstated assumptions that when men and women interact together about what flirtation is and what's a wink and a nod. And then maybe if the man is reading the wink and the nod a different way than the woman is, then it isn't consensual. And what is supposed to happen then? Because would we say a mistaken battery isn't a real battery just because you thought they wanted you to hit them? But again, I get a little off point because I want to say that we have this whole other stream about setting up policies, setting up trainings to make sure these things aren't happening, that there are avenues for people to understand what's expected of them, there's safe spaces set up. And then when these two kind of streams combined, again, in this administration, where the issue rose to the forefront, where the amount of women who reported that when they went to their universities, instead of getting open arms, they got cold shoulders, that there was a second round going on here where school officials were trying to discourage them from filing even the least formal complaints, where they were told that there would be, they were tried to discouraged from complaining, they were tried to be shamed into not reporting, and if they did report, there were retaliation. So to the extent that we've seen systems and incentives in place, for a long time the incentives have been weighed against complainants and against universities dealing with this issue at all. And that's a lot of what our Title IX guidance, which we've been issuing now, I think we're in our second guidance about sexual violence, just came out this year, is talking about process. Like when someone complains, what should you do? Should you offer them services? What kind of investigation should take place? If you choose to have a hearing, who should be allowed to participate? Should everyone have the same rights to bring on character witnesses? And we've identified a series of things through our investigations that we flag for folks, for universities, as things that if they do these things, if they allow the accused to cross-examine witnesses but not the person who alleged to be the complainant, or if they give one person all the documents beforehand and don't give them to the other, or maybe don't even let the complainant attend the hearing to hear what's being said about her, that those things are going to be process problems. And that, I think, leads into what I think Greg and I are going to be talking about a little later, which is a big theme that's coming around these days is this isn't a school issue. This is a law enforcement issue. And we have these tribunals that aren't set up to do sex stuff, be asked to do that, and it's not fair to the accused. And first, let me say, the only reason we're in this in the civil rights arena is, as I said before, because this has real consequences on who gets to come and stay and succeed in school. But I'd also like to just maybe, I'm not sure how I'm doing on time. You're fine. Okay. Point out what system you're offering in exchange for a system of complaint, investigation, hearing, and appeal. You're encouraging, you would rather see this done in a system where you report to police, the police can arrest someone on probable cause without a hearing. They bring them before they can put them in jail for 24 hours. They bring them before a magistrate who can decide, again, just on probable cause, whether to keep them in prison until their trial. And then after that, there's a public trial where maybe they're acquitted, maybe they're convicted, but they have an arrest record then for the rest of their life. They've been in jail, and they're acquitted, as opposed to a system where it's not shaming, there's no arrest record, and it's resolved within a campus community. Now, you may say one is better than the other because one is tried and true common law, and one is this newfangled system. But I would just caution you, as you're thinking about the costs and benefits of each system, the police officer who arrests you on probable cause, you can't sue him. He's got government immunity. You can't sue the prosecutor. He's got absolute immunity. While I know our friends here are saying there's lots of lawsuits out there against universities right now. So again, I'm not saying that the law enforcement system doesn't work, but I'm saying if you're saying that should be the primary or only way to deal with campus rape, and would it be the only way to deal with campus theft and campus arson and campus underage drinking and campus drug use? If all those things are supposed to be shunted through the law enforcement model, you're going to have a ton of kids with arrest records by the time they graduate from college. But I do want to add, going back to the model that a lot of schools have adopted, and there's a lot of models out there. There's an investigatory model, there's a hearing model, there's a dual investigator model. They all have lots of process in them. From our perspective, again, the laws we enforce, the federal laws that govern these situations, they don't require due process, but they do require a prompt and equitable grievance procedure to resolve complaints of sex discrimination. So prompt, that makes sense. Equitable, it's a broad word. What we've understood it to mean in our guidances for a long time is that if you give a benefit to the complainant or to the accused, you give it to the complainant. And that, in our view, leaves it up to the university to decide what are the processes that you should be giving folks. But it leaves to Title IX, to the sex discrimination laws, that when you're dealing with sex claims, both sides get a fair shot at whatever you're giving out. And then I think finally I would be remiss in saying there is this other law, Clery Act, which was mentioned before, which was named after a woman who was murdered in her dormitory room. I apologize, I can't remember if it was raped or murdered or just murdered. But it's a law that requires reporting. It is, in a sense, a consumer disclosure law that was being discussed earlier. It requires universities to give out warnings when they know something bad is happening on the campus, like there's an active shooter on campus. Clery requires that the community be informed. There's a rapist on campus. Clery requires the university be informed. And Clery also has a lot of rules that are relevant to the hearings now. And now, under the regulations that just got finalized, people will be allowed to bring an attorney if they wish, even if the university doesn't let either party bring attorneys. Accused and now complainants will be allowed to bring representatives. So Congress has recently intervened to try and create some national process issues, process consistency, to provide some bare minima due process. States, obviously, state institutions are subject to the due process clause, but surprisingly, for me, when I first started working on this area, there's not very much law out there about what due process requires of state university before they suspend someone. Are you required to get a hearing? Are you entitled to a lawyer? What part of the record do you see? So there's a lot of common law institutional work that's gone on out there, and the Congress and the Clery Act built on top of that, and our rules build on top of that by creating this equitable standard. I guess I would just end by saying, if there's a better way to do this, I would love to hear it, but this may also be contested. From my perspective, from a civil rights perspective, if you have a car, you should be able to park in any friggin' parking lot you want. And they can the fact that the university can say to you, oh, we have a rapist who hovers around the parking lot, that's nice that they inform you of that, but that's not all they have to do. Because if that's all they do, then women are going to have half the opportunities as men to park. And parking is obviously not the core benefit of the education that we're talking about here. But as Laura said, it's being able to go to the library without having to have an escort take you back if it's late at night. It's the right to go out alone. And these are things that are critical to becoming the independent people that we want colleges to graduate, to become part of our society. And we can't do that if the universities aren't responding to sexual violence by dealing with the sexual violence and not just trying to keep the women away from the people who are sexual violent. Thank you.
Something a little topsy-turvy here when a guy who spent his entire life as a civil libertarian is the one coming on talking about being hard on rape. I have the very unconventional opinion that I think that people who are actually guilty of rape should go to jail, but I'm going to talk a little bit more about that as I go on. I'm going to run through a slideshow pretty quickly just because since I have this opportunity to talk to so many of you from the Federalist Society, and I know you guys most of you don't specialize in this stuff, to really kind of do an overview of Title IX, how it affects harassment, and how it affects what's considered to be the subcategory of sexual assault on campus. And I just wanted to start out by reminding people what Title IX actually says. It's of course been amended, there's been things added to it, definitely it's grown a lot since day one, but it is an interesting, progression that we've moved from, the original idea of hostile environment that Seth talked about, that's the definition I completely agree with. That essentially if you're saying that you can have women on campus, but I'm going to make your life so miserable that you can't actually get an education here, then yes, that's actually, under that understanding it makes sense. But that would justify a standard like severe, persistent, and pervasive as discussed by the Supreme Court in a case called Davis. It doesn't explain the kind of stuff we've had to deal with. Now the problem with this standard was the hostile environment standard was vague and sort of enough for, frankly, ideologues on campus to take advantage of it in the 80s. And this formed the backbone of the logic behind campus, the first generation of what could be called politically correct campus speech codes. So a lot of people on campus took this and ran with it. And it got so bad that a previous Office of Civil Rights Department of Education had to issue a letter, and it's a terrific letter, I always refer people to this, where they make the point that the offensiveness of particular expression standing alone is not legally sufficient a basis to establish hostile environment. They're doing this because university after university is passing harassment-based speech codes that just ban merely offensive or uncomfortable speech, and they keep on getting shot down by courts from 1989 to today. In a sense, OCR was doing universities a favor by saying, no, the actual definition is sufficiently serious, pervasive, persistent. My definition, Fire's definition, we think we should go with the Supreme Court language on student harassment, going back to Davis, but that's more of an in-the-weeds argument that we have between OCR. But either way, we were very thankful for this clarification. And I'm going to move on to the assault part, but as Laura pointed out, these things are considered to be on the same spectrum. I actually think, and what I mean by that, harassment, that assault is just considered to be a kind of harassment, hostile environment harassment. I think this sort of strained way of looking at things creates some really weird results in some of the ways people try to look at assault, which has characteristics all of its own, under the same rubric that they're looking at someone who is just being really annoying or sexually harassing. I think that they should be considered, not viewed under the same rubric. So this is a point, since I have Seth here, I felt like I had to bring this up. the blueprint. If you know FIRE, you probably heard us talk about this. We talked about this an awful lot. And that beautiful, complex definition of harassment, the ones that have multiple prongs, in a letter to University of Montana, which they called a blueprint for every school in the country, they simply defined harassment as any unwelcome conduct of a sexual nature. All of those protections, all the Davis protections, just not there. And even though I got a letter addressed to me from OCR after months and months of fighting this, saying, well, no, we actually just meant that applying to University of Montana, kind of contradicting what they meant by blueprint, that schools across the country are starting to pass this incredibly watered down, and by the way, would be laughed out of court, overly simplistic definition of harassment. And several schools are already passing this as the controlling definition with none of those additional protections. So since I have Seth here, I want to ask that OCR issue a letter of clarification to every school in the country, reminding people of the standards in the 2003 letter, and preferably talking about Davis. Okay, so I wanted to do the speech part first, but again, these are related as far as the law is concerned. And I wanted to get to where we started really disagreeing with OCR on stuff, and that was the Dear Colleague letter of 2011. Now, this is a letter that gives, actually, I think, a fair amount of really good advice on how universities should deal with assault. And there's lots in it that we actually thought was fair and was actually an improvement on the way some campuses were handling assault. But it did do two things that we found very, very troubling. One was it instituted preponderance of evidence as a standard for adjudicating harassment, of which assault is considered one kind of harassment. We don't think that's good enough of a standard. Even though that's the standard in civil courts, you get a ton of additional protections in civil court. As far as we're concerned, the only serious protection someone accused of harassment on campus gets is the standard of evidence. And the idea that they're going with preponderance of evidence, which is described by administrators as 50% plus a feather, is not good enough as far as we're concerned. And then, of course, there's what we call the double jeopardy problem, not literally constitutionally double jeopardy, but by requiring that every university that has an appeals process have appeals both for the accuser and the accused is very much like double jeopardy, because it means someone can be exonerated of assault or harassment by a campus tribunal, but then they can have that overturned. They can be found guilty by whoever's up next to the chain, and that's troubling to us. But I gotta say, and there was a lot of pushback to the DCL. Here's some of the articles, but there was over 100 articles written there critical of it. Some of them, frankly, by me and people at FIRE. But here are some of the really good ones that I recommend you read. If you can take a snapshot of that, or I can give that to you afterwards. And meanwhile, what we've ended up with. So, and some of these investigations of universities, there's an interesting one that I discussed that's up there about Yale, and then there's another one that isn't up there talking about Princeton. And Princeton just came to a resolution with OCR that includes something that I didn't think was covered well enough, that they're going to be re-examining, their words, 11 cases of alleged assault in which the students were exonerated. And if you think about that from sort of an incentive structure, the idea that a university is going to be looking at students who are found innocent under what they perceive to be tremendous pressure to find them guilty, that's not exactly a formula for justice that I'm familiar with. And it gets to the heart of the problem of trusting universities so much with this stuff. I do absolutely believe that in the past, the problem had been that universities were primarily concerned about their reputation, so when they got rape accusations, they tended to kick it under the rug and say, let's not sully the university's reputation. Well, guess what? Nothing's changed. Just the pressure these days, I believe, is actually to convict no matter what. And ultimately, if you're going to trust an institution that's primarily, that isn't independent, that is primarily concerned about its bottom line, doesn't have all the checks and balances of other parts of our society, we can't really expect justice from that institution. And I think that ultimately we're on a fool's errand by trying to, and also, frankly, I see abuses in campus courts at every single level, so I am a particularly low ebb of trust of campus courts to handle even trivial things, let alone sexual assault or other felonies. So, and this is a case that I was talking about. This is, and we're starting to get actually this going up the chain. 28 professors at Harvard just came out against the harassment policy that was inspired by OCR and the Department of Education at Harvard. So I'm glad to see that there is finally starting to be some pushback. But I did want to cover, well, while I have you all in the room, some of the stuff that has me very concerned. And one of them is the rise, and one of them is this new law, CASA, which was supposed to be a bipartisan bill bringing people together to fight campus sexual assault. The problem is that it now allows OCR to fine universities up to 1% of their budget for each violation or failure having virtually no legal meaning that they find. And you have to think this through. The justification for the Office of Civil Rights and the Department of Education to have any power over universities in this field at all is the fact that they tie these conditions to federal funding, to primarily the funding of student loans. If you're saying that they can have power to fine you up to 1% of your budget, and they can do it for every failure, which you can easily find 100 failures in a single incident, that's actually saying that while they thought of this as a more sort of granular approach to punishing universities, this allows a university to get 100% of a university's budget over the years, if you word the thing right, which actually goes beyond the federal funding that a university receives. So we think this is it's also a terrible incentive structure to create for universities, for the Office of Civil Rights to be able to self-fund through these claims. So that's a law that I want people to be really aware of, because I think it's incredibly badly thought out. And then, of course, there is the issue of affirmative consent in California. Now, I know that the Office of Civil Rights Department of Education doesn't have a position on affirmative consent. My position is that they should have a position on it, and they should be against it if they care about the rights of the accused. Now, the way that the affirmative consent law is written in California is it requires essentially verbal consent, and it requires it to be ongoing for every stage in a sexual encounter. This is a law. It's funny, but it's the law now. This is what was laughed at Antioch College and is now actually the law in California. The CUNY system is adopting this. And the problem with this, there's a couple problems with this. One of which is that you have to prove that you're innocent. It flips the expectation on its head, going against all standards we have. Oh, and by the way, also it's impossible to prove yourself innocent. People have joked, the idea, oh yeah, if you have a videotape of your sexual encounter, well, no, not really. You'd have to have a videotape of the entire sexual encounter and probably some additional documentation. And even though this is funny, ultimately it means that an accusation under this rule, I'm hard pressed to think about how someone can prove themselves innocent under this, and this is a crazy way to try to address sexual assault on campus. And by the way, it's not just the fire and the public that's confused about it. The sponsor of the bill, when asked how exactly someone would prove themselves innocent under this, she answered, "Your guess is as good as mine." So, and I want to conclude, though, just by making this point. I do, and FIRE does take sexual assault seriously, and in this we've been talking a lot with the wonderful Rape, Abuse, and Incest National Network, which can hardly be accused of not taking this issue seriously, partially because they're one of the leaders in making sure that there are rape hotlines and this issue is in the public sphere, and they're with us saying that the idea that we can trust a crime this serious to little campus tribunals is crazy. That this is not going to produce the results we want. And what was interesting was one of the talking points by the Office of Civil Rights and Department of Education last time I actually did a panel with them was that research, and I'm pretty persuaded by this, has increasingly shown that the people who are actually raping between the ages of 15 and 25, and the rates, the rates, as best we can tell, are actually relatively similar on and off campus for that age range, tend to be multiple rapists. They tend to be serial rapists. And the idea that the best we can do against serial rapists, if that's what the data is showing, is kick them out of Swarthmore so they can prey on the 70% of the population that isn't wealthy enough to go to college, is an outrage. So I'm looking forward to questions and discussion.
All right, I think we have the debate, both cultural and legal policy regulatory framed. And I'd like to move to the rebuttal round and throw it open to the panel to the extent that you've got any spontaneous rebuttal to what your fellow panelists have said. I have a couple of questions that I'd like to pose, but let me throw it open to the panel first to offer some rebuttal. Anyone?
Well, I guess I would just reaffirm Greg's point, which is to call the feminists, take them at their word. If you really believe this is rape, it is also inconceivable that you don't want it to go to trial. And the fact to raise that, well, kids will have arrest records, that's in tension with one of the most powerful bits of mythology in the campus rape movement and the rape movement generally, which is that women never are mistaken about rape accusations. There was a huge attack on Stuart Taylor and Casey Johnson when they wrote about the infamous Duke lacrosse case, which was a fake accusation. But what we're always hearing is that, well, there's no ambiguity. There's not that there's not, and I do not think that these girls are consciously making a fake accusation. I think, again, we're in a realm of such emotional complexity with regards to regret, ambivalence, that they do come to believe, especially in the current environment of the feminist campus, that they were raped. But I do not think that they were by any reasonable definition. Why do the feminists generally oppose this going to trial? I debated Carolyn Heldman from Occidental College in September, and she explained. She said, juries are too steeped in rape culture. In other words, they can't be trusted to convict. And she actually said that the preponderance of evidence standard is too high. So, and she is very representative of the campus sexual assault administrator. In their view, the women's word is without the possibility of rebuttal. But again, if this is rape, of course, for God's sakes, send it to trial where the person can be thrown in jail. That is the only reasonable response.
And I did want to add something to that, which is that I definitely do understand the argument, and I think it's absolutely true, that there was a time in American history that we weren't taking sexual assault seriously enough, and it was within my own lifetime, I believe. But the argument for university tribunals handling this is essentially, when you get down to brass tacks, is that local police departments weren't taking this seriously. But it seems like we've completely skipped over the idea of, why don't we try to get them to take this seriously? Why don't we try to actually make this a law enforcement issue? Because I don't think it's the 70s anymore. I don't think it's the 80s anymore. I think that we have an opportunity to deal with this. But again, if we're talking about serial rapists, there's no excuse for just sending them out into the larger population, or chances are just to another college.
I'd like to step in here. I don't think anyone is saying that rape cases should not be reported to law enforcement or should not be handled with trials. I think in some cases that's absolutely the right response. The issue is that there's also a role for schools to play. It's not in place of law enforcement, but schools have an obligation to their students to protect them and protect the rest of the campus community. So in the case of serial rapists, which I agree with you is often the case, the law enforcement system is not such a sure shot. And in a lot of cases, police won't make arrests. Those students will still be on campus, and they will continue to victimize until they're stopped. In one study, 63% of college rapists reported committing repeat rapes, averaging 6 rapes each. And in that study sample, 76 rapists committed an estimated 439 rapes and attempted rapes. More than 2/3 of the repeat rapists admitted to other forms of interpersonal violence. Their violence was nearly 10 times that of non-rapists. And this is consistent with data on rapists and sex offenders in non-college settings. But again, and I don't think anyone, and perhaps Rain is in a different place than I am. I don't think anyone is saying that it's not, that serial rapists shouldn't be referred to law enforcement. What we're saying is that that doesn't always happen, and the school has an obligation to protect students. And just because, I mean, that actually goes against Heather's points, because she was portraying this issue as just an issue of students getting drunk and having misunderstandings or confusion, but in fact, these are often crimes committed by violent criminals who are purposefully preying on people who are vulnerable, and in a lot of cases plying them with alcohol until they're incapacitated.
Hi. I do want to clarify one thing, and maybe it's because I consider myself both a pragmatist, a civil rights advocate, and a civil liberties advocate, which I know Greg may not think I'm entitled to that mantle. But I would say, when I was saying, think about arrest records, think about cops arresting on probable cause, I'm living in a world, this world, where there are transaction costs with everything. There's huge problems figuring out the truth of what happened, and there's huge time lags as well, from complaint to arrest to arraignment to trial to appeal within a system. And we're talking about, in these folks' lives, 4 years. That's the expected tradition over a course of 180 days in fall and spring semesters. So we're working here with a system that isn't. If the criminal justice system could work in a snap and work the way Greg describes it, that would be a wonderful world to live in. But we live in a world where sometimes it doesn't work that way, and sometimes when it works that way, it takes a long time to get to justice. And the question is, as I think Laura mentioned, what does the school have to do, not as an alternative to whatever the criminal justice system is or should be doing, but to maintain its own responsibility to respond to a rape that occurred on its campus to one of its students, oftentimes by another one of its students? Can it just sit back and wait 6 months, a year, for the justice system to figure it out? And what if it's a plea bargain? Then what is the university supposed to do? What we've said for quite a while now is that you have to figure out yourself, campus, what happened, and when you do that, yes, figure out to the same degree you figure out a lot of things around your campus. Is it more likely than not? Is it raining? Did it rain yesterday? When we make these judgments, should I admit this student to school? Should I expel them for bad grades? Should I give them an extension? We use common sense standards of, is it more likely than not? And the reason I resist the labels like double jeopardy, or even saying that they committed a crime, these decisions are about whether you get to remain a member of the campus community. They're not about depriving you of liberty. They're not about depriving you of labeling you like a government can, a convicted rapist. These are about, should you be on the same campus with this person who, if we believe her, after a hearing, may have you forced her to have sex when she didn't want to. And that, I think, is why we have this second protection apart from law enforcement. So I'm not saying that either system is ideal, or that one system's better than the other, but I'm saying that given where we were, this is the system that schools need to have, regardless of what law enforcement is doing.
All
I
right,
just
Greg,
have-
and then back to Heather.
I
Go
have
ahead.
four quick points I'd like to make. Just four.
Okay, so one of my major points is that I feel like we've moved on without to universities, really clamping down on universities, getting tough on rape without actually doing this to local police departments. We haven't actually taken that step seriously enough, and I think that that's actually going to be one of the keys to fixing this. And the idea that we just leapt to the next one without doing that first is just bad policy. Second, campus courts don't work very well. And when it comes to either harassment or assault, actual victims aren't happy with them. The accused aren't happy with them. The campus community aren't happy with them. Nobody is happy with campus courts. But we keep on saying, well, if we just actually lowered due process and made the convictions easier, and this will all work so much better. It's like, no, we're never going to be happy with the results of campus courts, fundamentally because they're not independent bodies. They don't have checks and balances. They're concerned about how the university works. They don't have anything to rein in their own biases on these things, and they're going to either underprotect or underconvict or overconvict. Now, and one thing that's really important to understand, and we've gotten this from district attorneys that we've talked to, we're actually talking to a lot of them right now about this, because a lot of them are actually starting to get really angry by the fact that we've created this kinder, gentler adjudicatory system for felons. Because this is actually preventing local DAs from getting involved in cases where there's a serial rapist on campus, but because there's this kinder, gentler system that students can go to, that they're not actually making sure these people go behind bars. So there is a real cost to having this alternative system, and one of them is, yes, it is true. Sometimes you have to tell people who are victims of crime, if not for yourself, for the other potential victims of this person, please testify against this person. Please bring charges. And that's something that actual law enforcement can bring to the table. And a final point about due process. People always forget this, and it's not just that we're concerned about the rights of the accused, it's that we think that due process is a system for better accuracy. It's realistic about human biases. It's realistic about what happens when you just let people's prejudices get in the way. And believe me, I don't think it's just the case that innocent students are being found guilty of assault. I believe that genuine rapists are still walking free on campus because there is too much bias in a system that will always be there if you have professors of philosophy or career-long administrators trying to adjudicate felonies. Those are my 4 points.
I want to unpack this phrase rapist that is used so promiscuously, if I could use that phrase. You cannot have it both ways. You cannot say that there are serial rapists on campus and not want them to go to court. How can these two things be possible at the same time? The way they can be possible is the feminists have co-opted an extraordinarily powerful term that designates something that is inconceivably violent and cruel to something that is extremely different. If there are really serial rapists walking around on campus, not only should there have been a movement to create alternative learning spaces for women, we hear about safe spaces. This is one of the most nauseating rhetorics on campus these days. It is co-opted not only by women, but by gays and by blacks, that they need safe spaces. I would submit that there is no more compassionate, caring, safe, opportunity-rich environment in human history than today's American college campus for all of its members. But if we really need serial safe spaces, why aren't we saying there should be a total revamping of colleges' admissions policies? Because how is Harvard and Yale admitting rapists? So what was a telling, I think, observation by Mr. Galanter's part is that these girls shouldn't have to be on campus with the person who raped them. Well, again, let's imagine that somebody's come in your bedroom at night with a knife and rapes you at knife point, a stranger. It's not a question of whether that person should be on campus with you. He should be in jail. But what is going on is these are very emotionally charged hookup couplings. And yes, the girls don't want to have to see the guy again because they're embarrassed, because sex is complicated. And in fact, Jane Doe at Occidental College, one of her statements when she finally went and decided, she said, I don't want to have to see John anymore. So the girl gets to have the the prerogative of deciding who gets to be on campus or not, because it's awkward. It is admittedly awkward after you've had one of these drunken hookups to sort of have to deal with the guy the next day. That's what's going on. To call this rape, I think, is an incredible trivialization of what is a serious and real concept in human behavior that is, fortunately, I think it's aberrant, but when it does occur, it should be treated as the felony and serious crime that it is.
You know, this is not a new problem. It's getting a lot of media attention now because students are starting to speak out and come forward, and the government is taking notice, and advocates are working hard to try to change things on campuses, but this is not a new problem. So the idea that you know, it's also severely underreported. The idea that if it was a real problem, women would not be going to college or should not be, you know, it is preposterous. The idea that Harvard wouldn't admit a rapist is preposterous. How does Harvard know what, you know, an applicant has done? I mean, this is starting at the high school level, and people come into college with all kinds of backgrounds, and many are not caught. So it's not like they'll have a criminal record, but you know, no one's. I find it really offensive, and I wish there were some survivors here who could talk about their experiences, because I think this Occidental College example that Heather provided is an extreme example and just one story for which there are, you know, dozens of others that go the other way.
Do you think that Occidental should readmit John Doe then?
I don't know enough about the case. I'm not going to say
Well,
that.
then it's not, don't call it an extreme example. I would say it's pretty central.
Well, it seems to me that the first step in evaluating the propriety of the governmental response to the problem and the institutional response on the part of college administrators is to correctly define the problem, and we have a sharp disagreement about how to define the problem here, and I'm not sure we're going to get to the bottom of that here today, but I would like to pose the question about what empirically might account for these dramatic statistics that we've been introduced to here today about the response rates for rape on campus. The statistics are stratospheric, and it's either a fault in the empirical method. Heather, you're an empiricist, you've looked at this data, or it's something that's abetted by the culture, and I'm not sure we're going to resolve that question either, but I'd like you to address it if you could. Is there a failure of empirical method here that's propelling these statistics that are providing the impetus for the governmental response and the institutional response?
Well, the way these statistics are generated entails violating an absolute feminist cardinal rule, which is never to ignore women's account of their own experience. What they do is ask women questions that are broken down into various components of sexual assault, and then repackage that into saying, okay, because you answered yes and yes to these specific questions, we label you a rape victim. But as I say, when you ask the females who the survey authors have labeled rape victims, do you think yourself that you've been raped? They overwhelmingly say they haven't. So who do we believe, the females themselves or the poll givers? And I would say I would listen to the women themselves.
So it's a question of how to interpret the data.
Mm-hmm. Well, Seth cited a study. Go ahead.
I'm sorry. I think, you know, we're all, I'm a little confused now because, Heather, you said not too long ago that women developed some kind of false consciousness, that they truly believed they had been raped. But now you're saying we should believe what the women say about their rape description as long as they don't believe they've been raped. So,
Well, I'm talking about the gross numbers.
and I guess what I would say in response to that is Heather is talking about one study that I believe was at the high school level, and which was trying. What study are you talking about with this recharacterization of?
The Ms. study, again, 73% of respondents.
Yes, a
college
magazine
students.
study. But what we were talking about.
This is Mary Koss. She was at University of Arizona. It was commissioned by the University of Arizona. It's the same with the DOJ study as well in 2000. When you go back and ask women, again, 65% of completed rape victims in the Department of Justice 2000 study said that they did not report because their experience was not serious enough to report. 72% of the recent MIT survey said that their experience was not serious enough to report. It is inconceivable that somebody who has actually been raped would say that that experience was not serious enough to report.
And I guess we're just, again, at an empirical crossroads because in anonymous surveys sponsored by the government recently that have asked people, were you forced to have I'm sorry, let me get the exact language. Well, I can't find it right here, but physically forced to have sex against your will. Not asking them to reach a legal conclusion about rape, not asking them, anything about their sex lives either. It just asked about, were you physically forced to have sex against your will? And 10% of women, and a certain percentage
18%.
Thank you, and a certain percentage of men as well said, yes, that happened to me in high school. That happened to me before I was 25. And since it's happening to both men and women, and it's happening in anonymous surveys where there are no, there shouldn't be any shame filling out an anonymous questionnaire, I'm not quite sure how we can discount all those numbers and all those results. And maybe there are ways. I do not have the empirical background, but these are studies started well before this administration, long-time studies, and they haven't shown a huge change over time.
Well, against their will. I mean, the MIT surveys was, well, it was these studies are very poorly worded. The answer was, well, when you are too drunk. That's all it said, not even too drunk to consent. Against your will, yes, there can be misgivings, mixed signals. The evolving affirmative consent standard, that could also be now defined as against your will. Claremont McKenna's affirmative consent standard is now so far in the realm of Victorian values that females are not even expected to be able to produce the energy and will to say no. Here is their definition of withdrawal of consent. It can be an expressed no, or it can be based on an outward demonstration that conveys that an individual is hesitant, confused, uncertain, or is no longer a mutual participant. That is a completely unadministrable definition. But it gets to the fact that sex is complicated, and somebody can be confused and uncertain about whether you want to go forward or not. But to me, if you're in bed with a guy, that is a very different situation than completely forced sex that amounts to rape.
Well, the definitional question, I think, brings us back to the legal, regulatory, and institutional responses. And Seth, I'd like to ask you to respond, because I haven't heard a response yet, to the points that Greg raised about the burden of proof that ought to apply in these administrative tribunals at the institutional level, and the phenomenon of a thumb on the scale in favor of adjudicating guilt because federal funds are at stake, and then also the presumption of innocence being flipped by these definitional standards for affirmative consent that are in vogue in some institutions of higher education. I've got them listed here.
Okay,
so.
Good. Let me start with the preponderance of evidence. And first, again, empiricism. Before we issued our guidance in 2011, about 70 or 80% of higher education institutions were already using a preponderance of evidence standard. So this, the judgment of many, many, many institutions was that this was the appropriate standard to use for sexual violence cases.
That doesn't tell us why it ought to be.
It was also 9 of the top 10 universities in that study actually used, of the schools that were ranked the highest, actually maintained standards that were higher than preponderance of evidence.
Right. So I'm not sure which way that cuts. But I think the question of why, well, first of all, there is some wisdom in the masses. But I think the more important point is from our notion is that, as I said before, we want the regulation requires a prompt and equitable grievance procedure. And we have read that to mean that that both sides should have an equal opportunity to prove their case. That is, no one should be put at an advantage of having to prove to some great degree that that something has happened and the other person not. We also pointed out that if this case goes to court and for the university to be held liable, the plaintiff will only have to show by preponderance of the evidence that the university didn't do what it had to do.
That's when the university's monetary interests are at stake in a damages award as opposed to the student's reputational interests.
Well, I mean, and that's a good point. It is, what are the interests at stake for the student? It's not liberty. It's not the reputational interests such as to be put in jail for months at a time on probable cause. It is the question of, and it's not even reputational interests because most of these proceedings are, again, at the university's desire, private. The question is, do you get to continue to go to that institution or not? And we have not, as a society, constitutionalized that right and treated it the same as the right to liberty or the right to child custody. It is important right, but it certainly isn't a right that legally, in any state I'm aware of, has been given the kind of same right as the right to liberty or any of the other rights that trigger heightened constitutional standards. I also just point out that I think I heard Greg say that the preponderance really isn't the point, that no matter what process you're using, you wouldn't want anything decided in these judicial conduct proceedings. So I'm not sure that whether you think that that the standard is really changing things that much. Again, given how many schools were already using it. But if I could just go to the other point, which is about the thumb on the scale. And this actually goes to another point that Greg mentioned about re-examination. Like in Princeton, we asked them to re-examine. The point is, going back to where I started, when someone's raped on campus, it affects the person who's raped. It affects everyone who hears about it. It affects the conduct of all the people around them who feel less safe. And so when we say go and re-examine these cases, most of which are old enough that the participants aren't on the campus anymore, what we're really saying is if you got it wrong and there was a rape and people felt unsafe, you still have to do something about it. We're not saying, go dig through your files and see if you can put a red mark next to people's names who aren't at school anymore. We're trying, again, to get people who are there now feeling safe. And we are pushing for prompt adjudications, for fair processes, for compliance with the Clery Act. We're giving money to police departments. We're giving money to prosecutors to improve prosecutions, to improve training. But ultimately, we are not going in and judging whether a school reached the right result in a particular case. And we want is the process to work as it's supposed to work, but the outcomes are not something that we're holding them accountable for. Now, the outcomes of the adjudication.
All right. Greg, did you have a quick response, and then we have to go to questions?
Yeah, but I wanted to hear affirmative consent first, though. That was your last part of your question.
Yeah, Greg, as you know, the administration isn't saying anything about affirmative consent. This is a state-level issue. Schools are doing it. Our Title IX regulations, again, following the Supreme Court, talk about unwelcomeness. That is one of the very early cases about sexual harassment was a woman, her boss said, if you sleep with me, I'll give you a promotion. She slept with him, got the promotion, and then they had a fight, and she sued for sexual harassment. And one point the court got over very quickly was the fact that you slept with him consensually, that doesn't matter. The question is, basically, were you coerced into sleeping with him? So consent isn't a big part of our civil rights regime, but I understand many people are using it as the focal point for their discussion.
Well, I mean, my stance on it is that when you create a law that actually creates a standard of guilty until proven innocent, and it's impossible to prove yourself innocent, that is a very serious civil rights issue. So I would I'm gonna be hounding the administration, and I really think that the Department of Education should be taking a stance against it. I think it's going to work out badly for students, and in some cases, what I think the OCR would describe as some of the most vulnerable students.
All right.
But, sorry.
It's time for questions. We've got a lot of people lined up at the microphone. Go ahead, sir.
Thank you. My question is for Mr. Galanter and Mr. Lukianoff. Obviously, you've listed a number of various interests in having these campus tribunals, such as quick adjudication and the need for to have a separate adjudication over whether or not to keep somebody at the school if they pose a danger to the other students. But it's not a constitutional right. What about using what they use in labor law to resolve these issues, which is binding arbitration? There you would have an independent tribunal, so you wouldn't have the university putting its thumb on the scale to say, this is our reputation and we're going to automatically convict. And then the flip side of it is you get an independent process. And also, why not have it so that if somebody comes in and files a complaint of campus sexual assault, that one of the things the university is required to do is refer it to Department of Ed, refer it to the prosecutors, and refer it to HUD. And the third issue, and this is just a statistic I'll bring up, the average rape conviction in this country is 3 to 6 years. Perhaps it's time to think about whether or not it's appropriate to sentence somebody to 20 years for having a couple pounds of coke and then sentence them for 3 to 6 years for violently raping and assaulting a person.
Okay, to the arbitration point, I wouldn't expect you to state the department's position on the fly, but if you have a response to that.
I'm not, without weighing in on the arbitration point, a lot of schools are now experimenting, particularly smaller schools, are experimenting with consortium where they do get together and hire independent adjudicators or at least investigators to make decisions. That's, again, part of the response that's within the realm of discretion of an individual school district, or college or university. I guess I would resist the notion about these kind of mandatory reports, which was the last part of your question. What we find then is that some women report, some women don't report at all, even though, if they're getting some services, they would report to a college, they report to a counselor, but if they know that that's going to automatically get them in front of a cop, they're going to hold back, and then they're not going to get services that they need. So we're always trying to create, again, alternative avenues, the people who want to immediately report to campus police or local law enforcement, the people who want just counseling, the people who want counseling and not to be on the same floor of the dorm with them, and there's various gradations. But to have an automatic rule, if you tell someone, then you're going to be into the criminal justice system, deters too many people who have a problem, who feel I've been violated, but aren't ready to go and go to the public about it.
All right, anybody else quickly on that point?
I always get nervous because there's been this push towards a single investigator, and definitely for me, one thing that would help a lot was having something independent, which is one of the reasons why having sort of local police departments with SVU units, I think, could actually be the right one. But I'm definitely distrustful of any system in which the salary of the person doing the investigating is being paid for by the university. I think that compromises the independence and will either, once again, cause that body to either under-convict or over-convict.
All right, next, Professor.
Just one point, Mr. Galanter, I was a little worried about what I felt was still kind of this bait and switch about the term rapist. You're worried about having a rapist, that you'll have to deal with a rapist on campus, and the way we deal with that is through this procedure. But of course, the only way we find out with a rapist on campus in our justice system is we put them through a criminal process, not through this procedure. That's the definition of what's being a rapist, and that concerns me. And my question, though, is this. Isn't the real problem here to have a bureaucrat like yourself making these definitions for the entire United States without the ability, through if campuses just have a little funds, that you'll set these standards? What we'd have is different colleges would have different standards, and and there would be a sense that they would decide themselves what is the best kind of norm here. And we'd actually make some progress in understanding the best kinds of norms to deal with this kind of rather complicated situation. Isn't the problem here we have a one-size-fits-all without any experiment in dealing with what is a serious issue that may not rise to the level of rape, but how to have people deal with themselves as gentlemen and ladies on campus?
All right, why is this the federal government's business?
I'm really appreciate being the target of all these questions. And let me unpack both questions really quickly, because I don't want to suck all the air out of the room. But first, on my use of the word college rapist, what I'm trying to say, and perhaps there's a longer way of saying it, is, for example, O.J. Simpson was acquitted of murder, and then he went to civil court and was found liable for the murder of his ex-wife. Is it fair? Is it legally accurate to say he's a murderer? Or I suppose we would say he was found civilly liable for murder. Either, as a shorthand, maybe murder is accurate, and that's the way I meant when we're talking about when we're talking about what these courts do, what courts do and what these tribunals do. They are making decisions. They're not making the criminal judgment, but they are making a factual judgment about what happened. And if I should have been more clear and said they were making a judgment that this non-consensual sex occurred, then please consider my remarks amended. As for, again, why this is the federal government's business, Congress wrote the Clery Act to create this level of process. From a civil rights perspective, it derives from our determination supported by the Supreme Court, and I think with the right standards supported by Greg, that there's going to be conduct that occurs on a campus between students that's going to interfere with the ability of men and women to get the education they're entitled to. If that's motivated or sexual in nature, that's a civil rights issue. We are telling people there's 7,000 colleges and universities, there's 17,000 public school districts in the country. We can't go to each one and say, look at their policies and say, you're doing good, you're not. We have to give guidance that's generally applicable, and we do that through these writings, and we do them in a way where we do get feedback, we do issue clarifications, we have reiterated support for the 2003 guidance that Greg asked in our 2014 guidance. So it's our role because it's the role Congress gave us, and it's what we have to do given the scale of the educational institutions who receive the federal financial assistance.
Yes, next.
Mark Middleman from St. Louis. Does anyone on the panel think that it makes any difference that the subject we're talking about today involves adults who are voluntarily attending institutions to study academic subjects at a high intellectual level and not kindergartners under a compulsory attendance law in a public school?
I think
we find some unanimity on that.
Yes, we do.
Anyone?
Well, I wish they'd behave like adults. I mean, that's really the problem. And I wish schools would start behaving like schools by assigning some homework. Maybe if somebody was worried about their chemistry exam on Monday, they wouldn't be drinking themselves absolutely incapacitated. I mean, that's the real problem, obviously. I mean, I'm stating nothing new, is that this is all part of the drinking culture on campuses. And I find it extraordinarily depressing that institutions of higher learning whose mission is to cram as much knowledge into the empty little noggins of their subjects as possible are wasting their time in these incredibly lurid, just squalid proceedings when they should be about Thucydides and Aeschylus and Edmund Spencer, but they are going with delight into this squalid campus rape tribunals. And again, it's because they're not willing to say to men act responsibly and to women act responsibly and study instead of drinking.
Next.
Well, I'm a little bit nervous I'm making this question now because I'm an undergraduate, so empty noggin here. I am a classicist, which is why I was a little bit surprised by the Bacco reference, because Bacco is not about orgies at all, it's about alcohol. But anyway, my question is about the reporting of rapes by women. So I would argue that as a woman, it would be very hard to go forward with a rape allegation. Firstly, you have the problem that the perception of women being seen as perhaps being loose. Also, just very traumatic experience having to relive it at a trial. For example, at my university, University of Oxford, there were 2 women who came forward with a rape allegation, the same guy. It was covered in all the student press. They were given massive amounts of abuse by the accused friends.
Can you
it was
speak
very,
up a little bit?
sorry, is that better?
Yeah.
Yeah, sorry, just to recap, sorry, there was, these 2 women were given a massive amount of abuse, both by the accused's friends and by the media. And I was just wondering, this is obviously going to put women off coming forwards. And perhaps might explain some of the disparity in the statistics we were hearing. And I was just wondering whether anyone on the panel had any idea about how we can counter this problem, because until we have these women coming forward, it's pretty much irrelevant what we're doing on the side of justice, because they're just not coming forward.
Okay, to summarize the question, I think it has to do with peer pressure against making these reports, if that's a fair summarization of what you're asking. And you'd like the panelists to comment on that phenomenon on campus, that there is pressure from peers not to report.
I'm going to reiterate my point, and I was a little bit encouraged by a collaboration between University of Oregon and the local police department in Oregon, because really, to a degree, some local police departments have earned their reputation for not taking sexual assault seriously. But that's what I'd like to address first above all other things, to make sure that actually local police departments do take these accusations seriously, and you can actually get away from sort of the stereotype going back to this, which was earned, unfortunately, going back decades. But that, to me, always has to be the first step.
I think what you describe is very common in this country. Women who report sexual assault being doubted by the media as well as by peers. It's partly a cultural problem. There is an assumption that the woman was not telling the truth, or if a man says that they were in bed together, and it's assumed then that it's her fault if she was raped, forced against her will. We're working on a case right now of a high school student in Michigan who was raped in the band room at school, a soundproof band room, by a basketball player. And she then reported it to the school. The school didn't take it seriously, in part because the boy said that it was consensual, and in part because he was a very revered basketball player at the school. And so not only was nothing done about it, but then her peers, or his peers, were harassing her to no end about the fact that she trumped up these charges just to get him in trouble. And it was, terrible for her. So schools have a role here. If their role is to educate students, which it is, then they also have to send a message loud and clear about what's acceptable conduct and what's not. And part of that, they have a role in changing this culture that is clearly such a problem, both at the higher ed level, but also in our secondary schools.
Next.
Thank you. My name's Eric Roscoe. I'm a prosecutor with the Marine Corps, but nothing I say is representative of the Department of Defense. First off, in case anybody doesn't know, we've had this kind of issue. We've kind of dealt with it over the last year, and thankfully it's now focused on schools. One of the things that we do, well, first, we've been using the term rape and the term sexual assault. Those are different terms. So the individuals who are saying rape, you're talking about penetration sufficient with force that's sufficient to overcome the individual. When you talk about sexual assault, we're talking about lack of consent. And then the question of what's consent, the question of whether the individual is so intoxicated they cannot consent, that's a different issue. So it's not this force issue. And so sometimes you've been mentioning force, but you've really been talking about sexual assault. The issue that we face is about proving these cases. And so oftentimes we have stuff that isn't going to be tried out in town. So my first question is to you, Greg. You don't like preponderance of the evidence standard. We have cases where, look, we're not going to go forward. We don't have sufficient evidence to go forward at a court-martial. However, we do have sufficient evidence to separate that individual and tell them they're fired. And we do that through preponderance of the evidence. I don't know why that would not be sufficient at a school level, because that's the equivalent. They are firing a student. And then my second question for Seth is that, look, we have commanders who make our decisions for us. I don't have prosecutorial discretion. So I don't decide whether we go forward on charges. I have sat in a lot of meetings where the discussion has gone to, well, let's just put it through the process so we can find out what happened. That's not the right way to make that decision. And how do you think that you'll be able to address that as the Department of Education with schools? Because I guarantee you that those administrators are the same people as those commanders. And they're thinking the exact
We're
same
a little short on
Sorry.
time, so I'll ask the panelists to address those questions. One goes to matching the remedy
Sure.
to the burden.
Just really quickly, it's FIRE's position. We don't think that when you're dealing with sexual assault or rape, that preponderance of evidence is good enough in a system that's already broken. As I said, I feel like the only substantive rights that a lot of the accused get in these cases are the standard of evidence, and to lower that, I think, is actually a bad idea. We believe in clear and convincing. There is some case law that indicates when you're talking about sort of quasi-felony accusations, that preponderance of evidence might not be good enough. This is an ongoing discussion, but again, it's a position. We just don't think for something as serious as assault that POE is good enough. And I think it is partially predicated on the idea that automatically people are going to believe that the person who's making the accusation is lying. But I think that a lot of times when I talk to people on campus, saying that someone is lying in an assault is one of the worst things you could ever say. I mean, the Duke lacrosse case ended up being very much because nobody was on campus. They just automatically assumed an accusation was as good as a crime. So I think some of the cultural idea that people naturally assume that people are lying is a little bit it doesn't really jibe that well with university culture these days. But anyway.
Okay, in the interest of time, I'm going to let Seth off the hook and go to the next question.
Okay, my question is as follows. I'd like to know that all of the panelists would agree that rape is a serious crime justifying a severe penalty, first of all. And if that is true, which you may want to dissent from that, how is it anything less than hypocritical that the university, who has a role to play, as you just mentioned, in this issue, would do anything less than do everything in their power to refer these cases for criminal prosecution and the punishment that's due to anyone that commits a rape on campus or anywhere else in the United States of America?
Okay, I don't think we'd have any dissent on the first question, so maybe skip right to the second.
I think the choice to go to law enforcement is the choice of the victim, and schools need to inform her that she has that right, but it's not their decision. Their decision is whether or not to also have a proceeding in the school setting regarding this violation of the school code and the school and appropriate student conduct. So I don't think it's an either or. And in some cases, schools, even if the victim or survivor does not want to go forward to law enforcement, in some cases schools may have to override that and go to law enforcement if they think that there is danger of imminent harm to other students. So,
and for elementary and secondary schools, there's
Oh,
mandatory reporting
certainly.
laws
That's a different
at the state
story.
level. That's
Yes.
very different when you have a juvenile victim.
Right.
Okay, last question.
A couple times
pretty sure I heard this a couple times. I'm pretty sure I heard the statistic that 10% of men have reported being physically forced to have sex against their will. And Ms. McDonald mentioned St. John's and Thucydides. I went to St. John's, read Thucydides, so I can imagine times and places where that might be true. But in today's America, I wonder if anyone on the panelists knows who's raping all these guys.
I think that was a rhetorical question, and with that, we will end by thanking our panel.